Marc-Antoine Chasson is a lawyer in Moncton. He's representing Isabelle McCorkle in this case. Marc-Antoine, thank you for joining us this afternoon.
Good afternoon.
What can you tell us about this group down in the United States, and why does your client not want them to get this inheritance?
Well, the National Alliance is known as a preeminent neo-Nazi group based in West Virginia, and for several decades they've promoted hate, white supremacist agenda, and have been linked to acts of violence which were racially motivated. So, and I think it's important maybe we give a little bit of historical context in terms of why we're here and where we're going. I would say maybe about a month or so ago, our client became aware of the gift that her brother was intending on making to the National Alliance in his will. And when she found that out, that the gift was to go to this organization, she was certainly concerned and felt it was incumbent on her to do something to try to stop it.
Why are we dealing with this 9 years out? I mean, if this was in his will at the time he died, why is the inheritance still intact and not with this group already?
That's a very good question, and I think if we look at the timeline, Mr. McCorkle passed away in 2004, and the first application to obtain the letters probate, which basically means that the executor, once the letters have been issued, can administer the estate. That first application was only made in November of 2010. And if for whatever reason, they were only issued in May of 2013. And it was at that point that it became known that the gift, or that Mr. McCorkle intended to make that gift, and that's what the media reports, that's what prompted our client to act.
What can you tell us about McCorkle himself when he was alive? Why would he be interested in supporting this group?
We have no knowledge of that at this point. The information is pretty scarce in that regard.
So how do you fight a will here in St. John, or I guess he died in St. John, so you're going to do this in a
Correct.
St. John court. And what is it exactly that you're trying to argue there?
Well, I think the basic argument is this. The fact that a neo-Nazi group would receive a testamentary gift, in our view, offends public policy. It goes against public policy. And courts have in the past intervened when gifts under wills did offend public policy. And it's our view, based on the history of the group and what it stands for, what it advocates, that the gift itself, under Mr. McCorkle's will, is against public policy.
Forgive me, why does public policy engage here? I mean, is this not a private citizen making a private donation according to his own wishes?
That's a fundamental question. You have the private rights of a citizen versus the more global rights of the community. And what we have now, or courts have said in the past, that clearly the first objective for courts is to enforce private rights, either through contracts or wills. However, the fact that someone has made a private document does not trump public policy. In certain cases, when certain actions, private actions, have been taken, offend public policy, courts have intervened, and it's clear as far back as in the 1930s, the Supreme Court of Canada said the courts should intervene when certain private acts do offend public policy, which in our view is the case here.
Now, I understand, I think, if you're saying to me that we as a society do not condone hatred, hate crimes, racism, but again, this is a private man, his own savings. Why should the state, why should society interfere?
Well, I think if you have to put it in a larger context. Hate speech itself is specifically prohibited under the criminal code, first and foremost. Secondly, Canada has signed on to several international conventions with a specific objective and goal to get rid of hate speech, of hate groups, and the financing of hate groups. Plus, all provinces and the federal government have several legislation that protect human rights. So when you put that in context, we've made a choice as a country to not only condemn, these groups and their message, but also prevent them from flourishing. And that's why, by preventing, or by this gift being given to the National Alliance, in our view, would be helping a hate group flourish, which flies in the face of what we believe is the public policy that's accepted today in Canada.
Okay. What would McCorkle's sister like to happen to this inheritance instead?
Well, ultimately, the main goal is that it's prevented, that the gift is prevented from being given to the National Alliance. That's the ultimate goal.
And do you have a court hearing date? Like, what happens next?
Well, first, in terms of procedure, we filed a notice of application last week. The notice of application is the equivalent of a lawsuit, if you will. And then in the meantime, what we obtained earlier this week, an injunction preventing the estate to be dispersed or paid out until our application is heard on the merits of the case. But this injunction is only valid for 10 days. So we're now reconvening on July 31st of next week in order to argue that the injunction should continue until trial.
What kind of fight do you expect the National Alliance will put up?
That's a good, we don't know. We haven't had any idea of what their position will be or what response they'll bring at this time.
All right. Well, very interesting. Thank you for telling us about it today.
Thank you, Ms. Cave.